Have you ever looked at a law and thought, who decided this made sense? Well, today I want to play a game. I'm going to describe two people, and your job is to guess which one Arizona treats more severely. Most people get these wrong. And if you do, don't feel bad. There's actually a bigger lesson here about how criminal laws are created in the first place. But before we dive in, for those of you who are new to my channel, hi, I'm Joel Chorny. I'm a criminal defense attorney in Tucson, Arizona, and I'm trying to make the criminal system less mysterious and more accessible to people. But be aware that this video is meant for educational purposes only. None of what I say here is meant to be legal advice. If you have a criminal matter in Arizona and you would like my assistance, feel free to call my office at the number displayed on the screen. If your case is outside of Arizona, consult with an attorney in that jurisdiction. Okay, so with the housekeeping out of the way, let's start with the first example. Imagine two people. Person A steals a $10,000 watch. Person B doesn't steal the watch. Instead, person B takes that same stolen watch and pawns it. So here's the question. Which person do you think Arizona treats more severely? Take a moment and think about it. All right, so most people pick person A. After all, person A is the thief. Person A is the one who started this whole thing. But that's not how Arizona law works. If you steal a $10,000 watch in Arizona, you've committed a Class 3 felony. If you take that same stolen watch and pawn it, you've committed trafficking in stolen property, which is a Class 2 felony. To give you an example, a first-time offender faces between 2 and 8.75 years in prison for a Class 3 felony and between 3 and 12 and a half years for a Class 2 felony. For those who aren't familiar with Arizona's felony classifications, the lower the number, the more serious the offense. That means that Arizona treats the person who pawned the stolen watch much more severely than the person who stole it in the first place. Now, when I tell people this, they usually think that I've misspoken. They'll say, wait a minute, you're telling me that the person who actually stole the watch committed the less serious felony? And the answer is yes. Think about how strange that feels from a common sense perspective. If we were ranking blameworthiness, most people would put the thief first. After all, the thief is the reason the watch is stolen in the first place. Yet Arizona's classification system places the trafficking offense in a more serious category. That's not necessarily irrational. There are policy arguments for it, but it demonstrates something important. Criminal statutes are often designed around policy goals, not around what the average person would instinctively rank as the worst behavior. Now, to be clear, I'm not saying that trafficking in stolen property shouldn't be a crime. It absolutely should be. And there are policy reasons why lawmakers may have structured the law this way. If there's no market for stolen property, stealing becomes less profitable. One way to attack theft is to attack the ability to sell stolen goods. That's a perfectly reasonable policy argument, but it's not what most people expect. Most people assume that the thief committed the more serious offense. In Arizona, that is not necessarily true. Now, let's look at another example. Imagine that there are two other people. Person A gets arrested for driving under the influence while driving with a 10-year-old child in the back seat, while person B gets arrested for driving under the influence while driving on a suspended license. Which person do you think Arizona treats more severely? Again, take a second to think about it. Now, when I ask people this question, almost everyone picks person A. And I understand why. Most people hear that there was a child in the vehicle and immediately conclude that that has to be the more serious offense. But once again, that's not how Arizona law works. The DUI with the child in the car is a Class 6 felony. The DUI committed while driving on a suspended license is a Class 4 felony. In other words, Arizona treats the DUI on a suspended license as the more serious felony. And it gets even more surprising than that. There are actually several ways that a DUI can become a felony in Arizona. A DUI committed while driving on a suspended license, for example. A DUI committed while you're required to have an ignition interlock device, but don't. A DUI committed while driving the wrong way on a highway. A third DUI within the statutory time period. And a DUI committed with a child under 15 in the vehicle. Of those categories, the one involving the child is actually the least serious. The others are Class 4 felonies. The child in the car DUI, that's a Class 6 felony, which is the least serious class of felony. And unlike almost all of the other aggravated DUI cases, it does not carry the same mandatory prison consequences that people often associate with felony DUI offenses. Now, I'm not telling you whether that's good policy or bad policy. Reasonable people can disagree about that. What interests me is how often people are surprised by the answer. In both examples, most people's instincts point them in one direction, and Arizona law goes in another. Which brings me to the bigger point. Criminal laws are not laws of nature. There isn't some universal rule book that determines exactly how serious a crime should be or how severely it should be punished. Criminal laws are policy choices. Legislatures decide what conduct should be criminalized. They decide which crimes should be punished more severely than others. They decide where penalties should fall on the spectrum. Sometimes those choices reflect careful reasoning. Sometimes they reflect compromises. And sometimes they reflect concerns that aren't obvious from the outside. But they are choices. And because they're choices, they don't always line up with our intuition. Most people assume that if conduct A feels more serious than conduct B, that the law will treat it more seriously. As you've seen today, that's not always true. That's one of the reasons I encourage people not to rely on common sense when trying to understand criminal law. The law is full of classifications, exceptions, enhancements, and sentencing schemes that can produce results that surprise even experienced attorneys. Whether you agree with these particular laws or disagree with them, they illustrate an important reality. Criminal laws are not laws of nature, they are policy choices. If you can think of another Arizona law that seems counterintuitive or surprising, let me know in the comments. I'd love to hear it. And if you found this interesting, make sure to like and subscribe so you don't miss any future videos. I'm Joel Chorny. Remember, you have rights. They matter. Protect them. Stay safe, and I'll see you in the next video.